Good morning, everyone. Happy Monday morning. This is Carol Williams with Williams Immigration. And this is another edition of Beyond the Soundbite, where we talk everything U.S. immigration that is hot, that has happened in the past week, that I think you all will want to know about. So let's dive right in. So the first thing I wanted to talk about is we know during the last White House administration, there was a lot of applications that were rejected, not even receipted in, or we were given these really nasty RFEs, requests for further evidence, when there were blank spaces on the forms. So even if those blank spaces totally made sense, and even if they should have been blank, the service said that they should have had NA stamped in them. Well, that issue had some really significant impact on many applicants, so much so that that issue was litigated, went through the court system. We now have a firm decision that said that that was an improper way to do business. And so there is now a decision that essentially says that if you were rejected, if your application was never received in because there were blank spaces, now you have an opportunity to get these applications filed. So if your application was rejected between, on or before July 20th, you have until July 20th to refile. When you refile, you can obtain the original receipt notice that you would have gotten. So that's one thing that they're doing. If you have already refiled, they're saying you can refile again in order to get that original receipt notice, because those individuals that have already refiled have been given a later receipt date than their original filing date. And the Immigration Service is supposed to be going through their individual files and affirmatively reaching out to people to let them know that they can take advantage of this. I would rely on your own records. If you need help with that, if you're trying to figure out if this applies to you, if you need help refiling, feel free to give my office a call, and we can certainly point you in the right direction. The next thing I want to talk about is the public charge rule. I have been saying for a while, even though the prior administration's public charge rule was incredibly restrictive, that we were not going to just walk away and not have something put in its place by the current White House administration under President Biden. We now have a rule that essentially says, hey, look, we're going to publish something new. We'd like to get your comments on it. So that is out there. They've opened up the comment period for 60 days. So I will keep you in the loop on that. But again, the public charge rule, a new public charge rule, I think the Immigration Service is absolutely going to do. They believe it is important that individuals that are coming to the United States be able to financially support themselves. And this is not something that is going away, I do not believe, until there is a public charge rule in place that I think the current White House administration and the current USCIS administration thinks is a good balance between what we currently have and what we had under the prior administration, which again was incredibly restrictive. So that is out there, it is floating around, but I will keep you all in the loop on that as well. Excuse me. We do have a fairly new announcement that as of October 1, if you are applying for permanent residence, or otherwise known as a green card, in the United States, you must be vaccinated against COVID-19. You must have received that vaccination in order to be approved for your green card. There is a very limited scope of folks that do not have to be vaccinated. That will require, you will need to explain that to the panel physician, and then you will need to also explain that to the U.S. Immigration Service. But by and large, plan on getting the vaccination if you would like a green card. If you have any questions about whether or not you may qualify to not get the COVID-19 vaccination in advance of receiving your green card, feel free to give our office a call, and we're more than happy to have that conversation with you as well. But that is something extremely, extremely new. The CDC has instructed the USCIS and overseas approved physicians that they must be looking for the COVID-19 vaccination for green card holders. For my employers in the US, many of you are still working remotely, or your workforces are working remotely. That said, immigration has once again extended your I-9 flexibility, and that extension now goes through December 31st of this year, where you may continue to review the supporting documents for the I-9 electronically. It does not have to be in person. With that said, please be thinking of a mechanism and manner and process that you will put into place when these flexibilities are ended. At that point, you will have to look at these documents that we have now been looking at for over a year. You will have to look at those documents in person. So please don't sort of do them and then forget that you looked at them electronically rather than in person. That is also very critically important for individuals that are in charge of the I-9 function over multiple offices, and in fact, sometimes over multiple states. You will need a process in place to review those in person. If that is something that you need assistance with, my office is more than happy to help with that. Feel free to give us a call at 954-903-1337, and we're happy to talk with you about that and help you develop that process if you don't already have one in place. So more great news for employers. We have received notice that TPS for certain individuals will be extended through December 31st of 2022. So through December 31st of next year, TPS has now been extended for individuals from El Salvador, Haiti, Nicaragua, let me make sure I get all these, Sudan, Honduras, and Nepal. That means that these individuals are receiving work authorization, so their work authorization will be extended. So you will have until December 31st of 2022 when you're looking at employment options for these individuals. So that is great news for our employees that tune in every Monday. The next thing I want to talk about are the green cards. So consulates across the world are still operating at less than full capacity because of the COVID-19 pandemic that we are still in. And they've had to prioritize how they are processing their green cards overseas because they are working with limited staff and probably limited hours as well. So just so you have sort of a peek into how they have prioritized. This is not all of the application types that they process. These are just a few that I thought you all might find particularly interesting. So in their first tier of processing are those cases where individuals are going to age out of eligibility for green cards. If you are a derivative, if you're a dependent family member, you age out, meaning you no longer can be an automatic dependent of your parents and receive that green card through your parents' application when you are over 21 or you are under 21 and married. But usually that magical date for most children is 21. So those cases are in the first tier of prioritization. In the second tier are immediate relatives. So spouses of U.S. citizens, parents of U.S. citizens are in that immediate relative category. Also, the fiancés of U.S. citizens are in that tier 2 category. In the third category, we sort of have all of our other family preference cases. So if you are the family member of a current green card holder, then you are going to be in that third tier of processing. So that leaves in my fourth tier, and the tier that's going to be processed last, that's going to be prioritized last in each consulate, anyone that is applying for a green card through their employer and they happen to be processing that green card overseas. So that is something that you want to take into consideration when you're thinking you're an employer and you're thinking about processing a green card, whether that person is overseas or in the US. If they're overseas, that application process is going to, at this point, take a little bit longer because employment-based green cards being processed at consulates are indeed in their tier 4 category of processing. Back stateside, if you're in the States and you are going into any USCIS building for any sort of appointment, so if you're going in for an interview, if you're going to be sworn in as a new US citizen, or if you're going to get your biometrics taken, masks are required, as is social distancing, regardless of your vaccination status. So that is very important to know. When you get to the USCIS controlled buildings, please follow all of their instructions so that they can do their best to keep you and everyone else in the building as safe as possible. So I want to move on to my F1 OPT students. We've known for quite some time that receipts in general have been a little slowed. Receipts for our OPT, for our EAD, for our employment authorization documents are very slow right now. And that is having a very significant impact on our students. Our students are under a very, very tight timeline with which they need to file for their OPT. In the past, there has been very, very little wiggle room regarding this timeline. Because of these slow processing times, the Immigration Service has now, pursuant to a court order, essentially allowed for flexibilities to extend those filing times. So if you are filing your OPT and it was received by USCIS on or after October 1 of last year, so on or before October 1 of 2020, up through and including those applications received up through and including October 31st of this year, 2021, then you can file your application for your OPT EAD 120 days before your program end date. This is because the EAD receipt notices and EADs in general are taking longer. They are severely backlogged. So the Immigration Service, via court order, this is what they've been ordered to do, so this is what they are doing. This extension of filing time should give our F1 OPT students time to actually apply, get their receipt notice, and get their green card, not their green card, their employment authorization document, so that they can start their OPT employment. So that is great news for our OPT students. If you are scheduled for biometrics, it used to be that you would send in a letter and say, hey, I can't make my biometrics appointment. Can you reschedule? No more of that. Absolutely no more writing in and telling CIS that you can't attend your biometrics appointment. All biometrics appointments must be rescheduled by calling the customer contact center number, which, so you have it, is 800-375-5283. That is the number that you need to call if you need to reschedule your biometrics appointment. Please know, when you call and reschedule, you do not get to pick your new date and time. So if at all possible, I always tell my clients that you really need to prioritize your biometrics appointment and move everything else around it. They don't tell you how long it will take for you to get you a new biometrics appointment. And so we just want to make sure that you are getting your applications processed. But no, you must now call to reschedule your biometrics appointment. And it sort of goes without saying, but I'm going to say it. You must call to reschedule your biometrics appointment before your biometrics appointment is actually, due to take place. You cannot call and reschedule once you have already missed your biometrics appointment. as they will most likely move to deny your application for failure to show up to your biometrics appointment. So please keep that in mind if you need to move around your biometrics appointment for any reason. And the last thing I want to talk to y'all about this beautiful Monday morning is the removal of conditions application. The receipt notice now automatically extends the time of your underlying conditional permanent resident green card to 24 months. That is because of the backlogs. This is one more mechanism, one more thing that the Immigration Service is doing because they recognize that they are processing cases slower because of a myriad of things, but really the big one is that we're sitting in the middle of a pandemic and workforce is working slower. There are fewer people working. People are sometimes out sick. So they are sort of rolling with the punches the same way that we are. But your 751, your removal of conditions, receipt notice will indeed automatically extend your underlying green card for 24 months. Folks, that's all I have this morning. I am Carol Williams. This is another edition of Beyond the Soundbite, where we talk all things immigration. If you have any questions, comments, concerns, please drop those in the comment section. I do go back and look at them. Sometimes I will reply to you personally, or I'll just put my response to you in the comments itself. Again, Carol Williams with Williams Immigration. It has been a fabulous Monday morning with you all once again, and I will see you next Monday morning. Bye.